All right, we're now moving on to Note 12, which covers the topics of discrimination and diversity. The issue of discrimination, of course, goes back to slavery and back to the time of the Civil War. After the Civil War, Congress wanted to make sure that the issues surrounding slavery could never be repeated. And in the 1870s, a number of years after the Civil War, they passed three amendments to the Constitution, the 14th, 15th, and 13th Amendments. The 13th Amendment was easy enough. It abolished slavery forever on any U.S. territory, possession within any U.S. state, or any territory that would come into possession of the United States. The 14th Amendment said that every person is first and foremost a citizen of the United States, not of their individual state, and that all states were required to give equal protection and due process of law to all citizens, to all individuals, and the 15th Amendment guaranteed the right to vote to all free men. Of course, the Supreme Court was not in the mood to deal with any of this in the 1870s, and they basically fell asleep at the switch, did very little to help Congress or the presidency enforce any laws or provisions that came along under these amendments. And even though some laws were, anti-discrimination laws were passed on the federal level, the states were allowed pretty much to continue to do what they had always done. And of course, over time, in the late 1800s and the 1890s, the Supreme Court came down with the case of Plessy versus Ferguson, where they said that separate but equal was constitutionally permissible, and began to allow the growing of the apartheid system of separation of blacks and whites in all public accommodations, schools, restaurants, on buses, on trains, that existed well into the 1960s. Beginning with Brown versus Board of Education in 1954, the Supreme Court took a radically different stance and first began by desegregating the public school systems and began looking at other aspects of discrimination. With the election of John Kennedy in 1960, he promised that they would work, the Democrats would work on helping to end the discrimination that existed in our country. And of course, he was assassinated during his first term and was unable to carry this out. But Lyndon Johnson, who was a Texan and a Southerner, so surprisingly picked up where Kennedy had started and where certainly Martin Luther King and the other civil rights leaders were pushing for change and for development in the law. Eventually, this all came down to something called the Civil Rights Act of 1964, which basically set the rules and provisions that we still follow today in terms of trying to end discrimination, both by the federal and state governments and in the private sector marketplace. Title VII of the Civil Rights Act of 1964 specifically deals with employment, and it basically says that discrimination is not allowed for certain groups of people. Now, we first of all have to define discrimination. Discrimination, in terms of the law, is unequal or unfair treatment based on certain characteristics, and those characteristics are race, color, national origin, religion, sex, sexual orientation, and just recently, in the case of Bostitch versus Clayton, the Supreme Court last month handed down a decision that says that when the statute talks about no discrimination because of sex, that extends to even gender identity issues. So very broad coverage in types of situations where you are not allowed as an employer to discriminate. And discrimination is considered any type of unfair treatment based on those categories or classifications in hiring, firing, promotion, pay rate, job assignments, we said promotions, but basically covering all aspects of employment. The federal government, through Congress, set up something called the Equal Employment Opportunity Commission, the EEOC, and they have the obligation of monitoring this law for the federal government and making sure that it is enforced. They basically can deal with individuals. Individuals can file complaints against their employers. There have been some attempts to maneuver this into a class action type of situation where you might have multiple plaintiffs bringing suit against defendants who have violated these laws, but the Supreme Court has been somewhat hesitant to allow that to go forward. So basically, we still see these cases today coming forward on an individual by individual basis. However, once they reach the level of the Federal Appeals Court or the Supreme Court, any decision that gets handed down becomes precedent for the rest of the federal courts. And if it's applying a constitutional principle, then it becomes precedent even for the state courts to follow. So even individuals bringing a case can make a tremendous difference in moving forward in this area. Now, in order to show intentional discrimination, the plaintiff, the person who says they've been discriminated against, must, number one, show that they are a member of one of these classes, that they have applied for a qualified position, that they were rejected for that position, and that the employer continued to seek persons to fill the position even after they had interviewed them, had spoken with them, or somehow dealt with them. If you can show this, this constitutes what's called a prima facie case. Prima facie means basically first face or first glance. And what happens in our law, and any of you who have had litigation or have taken tort law, you understand that the initial burden is on the plaintiff to prove all the elements, to prove what's happening in a case. And once they do that, we have said that they have met their prima facie case, and then at that point, the defendant must rise up and bring in evidence and testimony to show that they should not be ruled against, that the plaintiff should not win. Right? And so once a plaintiff has fulfilled these obligations with evidence, fulfilled these criteria with evidence, they have basically proven their case under the law, and now the defendant must put up a defense to prove basically that they did not discriminate. So the burden of proof in effect swaps from the plaintiff having to come forward and prove everything to now, having met this basic threshold, now the defendant is on duty having to prove and bring in evidence that they did not discriminate. Unintentional discrimination is a little bit more difficult to prove because here we don't really have discrimination aimed at a particular person for a particular position or in a particular situation, but we're trying to prove that overall minorities are underrepresented, or they're not represented in management, or they get lower salaries, they get fewer raises and bonuses than non-minorities. That testing is set up in such a way as to be discriminatory and to prevent minorities from filling positions or moving up in positions, so that you can prove that there is just sort of general discrimination going on without a specific finding of discrimination against a specific individual, but it is a more difficult case to prove, and it requires a great deal more evidence, and the burden remains on the plaintiffs at all time in these cases. They must basically push through to the end to prove that there was discrimination going on here in a systematic or a general type basis within a company or within a government bureaucracy. Reverse discrimination is kind of a funny concept. It's not particularly a legal concept. It's the idea that we will put in place quotas, we'll do certain things to ensure that minorities get a certain percentage of jobs, a certain status within the work group, within the company, even if that works negatively against majority individuals. This is equally, if this is done as truly reverse discrimination, this is equally illegal, and it can be equally fought in the courts. You have to differentiate this from affirmative action, and it's a somewhat difficult thing to do. So reverse discrimination is basically saying to the majority of folks who are your employees, your workers, no, we're going to put you aside because we need to focus on minorities now. So you have to take a back seat. You're not going to get the raise, you're not going to get the promotion, we're not going to hire uh, anybody from your group. Affirmative action is a little bit different. Affirmative action allows race to be one of the criteria in choosing a candidate for a position. So it cannot be the sole criteria. So you cannot really set a quota and say we're going to accept so many whites, so many blacks, so many Hispanics, so many Native Americans, and so many Orientals. But in the overall process of choosing someone for whatever it is you're choosing, a job or admission to a school or a raise or a promotion, you can use race as one of the criteria. And the colleges and universities have been particularly adamant about using this as one of the criteria and saying that one of their goals, one of their necessary realities is to have a cross-section of society, a cross-section of the community be part of their student body, part of their faculty. So therefore, that while race cannot become the sole criteria on which they hire or fire somebody or admit somebody to the school, it can be part of the mix. And so far the courts have pretty much allowed, there have been mixed decisions over the last 30 years going back and forth on this. And so long as the affirmative action does not reach the point again of being a number type criteria that, oh, we're giving a certain percentage of seats to a certain group and no one else can get them. So long as you're not that severe in it, the courts generally tend to allow it without really liking it. I mean, the ideal in the 1960s was thought that we would someday reach a point where we would have entirely race and gender neutral society where these things were not even part of the consideration process. Of course, we're far from that, and every time we seem to make a step or two forward in one direction, we go backwards in others. Congress created a cause of action similar to a tort for people who have been subject to discrimination. 42 U.S.C. 1981 allows you to sue for damages for discrimination. All right. In terms of religion, you cannot discriminate against someone because of their religious beliefs, and you must make reasonable accommodations for their religious practices. So if they have certain modes of dress, if they have certain holidays that they celebrate that are not the customary civil holidays, you have to give at least reasonable accommodation to that, so long as this is not severely detrimental to your processes, to your workings, and to your ongoing corporate business. In gender situations, the law has now reached a point where employers must make accommodations for pregnancy. There must be equal pay for equal work. Again, sometimes these are enforced, sometimes they are not. Very difficult at times to bring cases to prove these things. One of the realities here, we're kind of skimming over this area of law, but there are attorneys who do nothing in their entire legal lives but practice in this area and study the cases, the statutes, and it can get to be very confusing because we generally tend to talk about federal statutes and we tend to think about these as federal issues because they're tied into the Constitution and to congressional statutes, but the states are allowed to have their own anti-discrimination laws so long as they're tighter and not looser than the federal laws, so long as they give more protection to individuals and they don't try to undo the federal protections that exist. So very often in a situation you have a very confusing melange of state, federal, and local laws and regulations and trying to figure out what best applies, what will best protect the employee. So it is a very, very interesting but very complicated area of the law. And as I said, many attorneys spend their entire legal careers doing nothing but working in these areas. Sexual harassment has come to be part of all of this. And the idea of sexual harassment is that, number one, it could be a quid pro quo, something for something. We want sex for you to advance in your job, to keep your job, to get that raise, whatever. Or it could also be a hostile work environment where constant sexual activity, undertones, innuendos make it uncomfortable for a person to be employed. Employers can be held responsible even if the harassment is carried out by another employee or by a supervisor. So it's not just a situation where company policies enter into the sexual harassment area, but the actual day-to-day activity. So a corporation can have the most wonderful policies on the books, but if in a particular place, a particular division, particular work site, they are being ignored, the policies are being ignored by individuals or by low-level supervisors, the entire corporation can be held responsible for that. All right. Sexual harassment can be by the same sex. So it can be men picking on another particular man, and or women reacting against a particular woman. It does not have to be against the opposite sex. And it can also be, at this point, they've been moving into, the case have been moving into looking at it in out-of-work situations. So on social media, on Twitter, on Facebook, on YouTube, on things being done out of work, nasty emails, sexually explicit emails and innuendos from a fellow employee or supervisor, even when made off time and off duty, can still be considered as creating a hostile environment and can be actionable, and that action, again, can be taken not just against the violating employee, but can be taken against the employer on the theory that the employer should be watching for these things, should be working to mitigate these things and making sure they don't happen. Under all of these different things, the courts have great latitude to apply remedies and punishments. They can impose fines, they can impose injunctions and court orders to prohibit certain activities or to require certain things such as training programs and hiring of people to monitor situations. The statutes basically give the courts a great deal of power to prevent discrimination in any of its various forms. Now, age discrimination was not originally part of the suspect classifications that came out under the Civil Rights Act of 1984. We had to wait until the late 1970s where we ended up with a special statute, the ADEA, Age Discrimination and Employment Statute, being passed to make sure that people were not being discriminated against because of their age. The statute protects people over 40 up to the age of 70. Past 70, an employer can use your age as a reason for not hiring you for a position. But between 40 and 70, they cannot use age as the sole criteria in giving someone a position. So they cannot hire a younger person over an older person who has met all the other qualifications for having the job or having the advancement. Many of the federal safety rules, federal anti-discrimination rules, do not apply to state employees because there's something called the 11th Amendment, which basically says that the states are still sovereign entities. They still have all powers not taken away under the Constitution and given to the federal government. And when it comes to states dealing with their own workers and their own employment situations, the courts have hit or miss, more or less, said that states have a number of powers to ignore the federal laws when they're dealing with their own employees. This really isn't too much of an issue anymore because in most of the states, the anti-discrimination laws and regulations are far tighter at this point than they are on the federal level. So it's a rare situation where this happens, but there are situations that still come up where a state employee feels they're being discriminated against based on one of the suspect classifications, and the federal courts say there's nothing we can do. You have to go and deal with your state government because they retain power in this area. The Americans with Disabilities Act, again, was not part of the original Civil Rights Act. It came along later, and it basically said that employers cannot discriminate against the disabled and make that a sole criteria again for refusing them employment or refusing them a raise or advancement. Um, the criteria for determining if someone is disabled. It could be a major mental or physical impairment that limits major life activities. There is a record of having such impairment, such as a medical record or social work record, and that they still have that impairment and it affects their abilities. The employer is required to make accommodations to meet the needs of an impaired or disabled employee, so long as that would not cause undue hardship to the employer's line of business, to their work. Um, Substance abuse is considered an impairment, and in many states in particular, there must be health insurance given to people who are dealing with substance abuse, drug and alcohol, particularly. All right. Finally, in this, defenses to discrimination. Business necessity. Sorry, folks. And this, again, we're talking now about the Americans with Disabilities Act. A person who is unable to use her arms and legs certainly cannot expect to obtain a job with the electric company working as a lineman, climbing up in the buckets and stringing wire and doing these heavy, difficult physical jobs. Somebody that was wheelchair bound probably could not expect that. Seniority systems set in place by unions can sometimes also stand in the way of giving accommodations. The law is not particularly clear on exactly how a seniority system versus somebody who's disabled, how, if those come into conflict, how that would play out. The court decisions vary on that. And the employer can always attempt to prove that you do not have a bona fide occupational qualification, that you are disabled, but that's not the reason we did not choose you for this position or for this raise or for this job. The reason we did not choose you is because somebody is more qualified. They have more ability, not necessarily ability, but they are more qualified in terms of education and experience to do the particular job. They have a license needed for this particular thing. They have had intensive training. All of these things would go to show that the employer was not acting in discrimination against somebody with a disability, but that they were weighing all the different things to see who was best suited for the job. That is about all I have to say for Note 12. So we'll call that an end. We'll see you again shortly in Note 13.